Today, I'm going to show you how to prevent an unscrupulous person from changing your will before you die. Most people think that if they prove mom or dad lacked capacity when they made a will, the court will simply throw out that will. But in the real world, capacity often isn't the problem. Vulnerability is. Okay, here's the scenario. Your mom made a will, leaving her estate to her 3 children in equal shares. She revised the will a couple of times, but the equal division always stayed the same in every version of her will. Then, years later, she dies, and your sister-in-law brings a newer will to the probate court that leaves the entire estate to her son. You look at the will, and it was drafted by a different lawyer than the last one, and it was made not long before your mother died. Do you think this is uncommon? Well, it isn't. It happens all the time. Now substitute for sister-in-law a black sheep brother or nurses or a home health care worker or the real estate agent who helped your mother buy her assisted living condo. The list goes on and on. But the upshot is always the same. Not long before death, a new will is made that radically alters the long-established and often repeated intentions of the old will. I'm going to tell you how this happens and what you can do to prevent it. If you're the one making the will or estate plan, you need to understand that people change with age. And you will change with age. You may become more susceptible to suggestion, more trusting. You may no longer remember important parts of your life. So if that happens to you, how can you stop someone from changing your estate plan? If you notice changes in a loved one, how can you protect them from that kind of abuse? This episode is our first episode specifically for both lawyers and lay persons who want to learn. I'm going to give some technical legal solutions to this issue, but realize it's a wide-ranging issue and it comes in so many different varieties that for the lawyers out there, I'm going to narrow down the problem to only 2 or 3 variables. There are many ways to address this problem, but I'm going to focus on a particular client profile. This is a client whose estate is under the gift taxable limit, so we're aiming for inclusion at death to get the step up in basis. Also, let's assume that we're certain of the independent judgment of the client who is making the plan and thinking prospectively. That is, we're making that person understand what the future could hold and giving him an option to protect the estate plan from changes made due to a future vulnerability. Quick roadmap. First, I'll explain the failure point in plain English. Then I'll give families a few practical guardrails to ask about. And then I'll switch to the drafting architecture for lawyers. One of the most common and least discussed failures in estate planning is not fraud, incompetence, or bad drafting, but what happens after a good plan is created. A previously competent settlor becomes cognitively vulnerable. Add that vulnerability to the low bar that the law sets for capacity needed to make a will, and you get what we call the quiet rewrite of the estate plan. This episode explores how traditional doctrine fails to protect intent, why undue influence is structurally hard to litigate after death, and how a carefully designed, protected, limited power of appointment can address the problem without sacrificing tax or Medicaid planning goals. So here's how this happens. You, or maybe it's your parents, after they've been retired a few years, decide to make a new will. They're fully competent and they create a thoughtful estate plan. The plan reflects fairness, long-standing relationships, and shared expectations. It includes equal treatment of children, carefully calibrated trust provisions, and a retained testamentary power of appointment for tax or flexibility reasons. Then, many years later, Dad's on his own now. Mom has died. Cognitive decline begins. Not necessarily total incapacity. Then a caregiver, maybe it's a new spouse, maybe it's an in-law, or a helpful companion, enters the picture. Technically, under the law, the will maker or trust maker still has the legal capacity necessary to make a new estate plan, but he's suggestible, overly trusting, emotionally dependent, or eager to please the last kind person he interacted with. That's when the quiet rewrite happens. Quietly, without anyone else knowing, the settlor is taken to another lawyer. A new will or trust instrument is signed. The dispositive or gifting scheme changes, and the change is only discovered after death. So why does the law fail to stop this? The reason is that testamentary capacity is a very low bar. Basically, if that person knows their closest family members and knows they own assets and knows that a new will changes who gets those assets at death, they can sign a new will. But what does that look like in real life? It sounds nefarious, and sometimes, yes, it's an opportunistic person who has physical custody of an elderly man or woman, dragging them in by the shirt sleeve to a lawyer willing to overlook the sundowning. But the cognitively impaired can fool even an honest lawyer. I once had a woman pass that test. She appeared clear-eyed and answered the questions. There were some details she missed, but they didn't seem material. And then, after the meeting, she stood and her daughter met her at the door. She looked at her daughter, smiled an impish smile, and recited her former answers as though they were a children's nursery rhyme, but out of order and incoherently. And then she did a little dance and sang this song. I'm hula loo. I'm a gal that can't be true. I do my dancing in the evening breeze. 'Neath the trees, I've got more sweeties than a dog has fleas. Well, needless to say, I revisited that capacity test. Passing that test of who is allowed to make a new last will is pretty easy. The legal standard for testamentary capacity is intentionally minimal. It asks whether the person understands they're making a will, knows roughly what they own, and recognizes the natural objects of their bounty. What that test does not require is the ability to resist pressure, independent judgment, consistency with prior intent, or freedom from emotional or personal relationship distortion. A person can pass the test and still be the victim of manipulation. Manipulation that isn't obvious at a meeting in a law office. But can't we sue for undue influence? Undue influence litigation, that sounds protective, but it's structurally flawed. The key witness, the person who made the will, is dead. Evidence is circumstantial. The burden often shifts only after presumptions are overcome. Litigation is expensive, divisive, and uncertain, and a no contest clause actually deters a rightful challenge in that case. That is, when making the new will, there is a clause that says, if the disinherited child objects to the last will, that child gets nothing. So the law provides a remedy after the damage is done, but not before. That's where a good estate planning lawyer can make a real difference in the lives of these families. And I'm going to give you lawyers listening an excellent tool to address this issue. If you're a family member listening, here are 3 guardrails to ask about. First, if mom or dad becomes vulnerable, who has the practical steering wheel day to day? Second, if someone tries to change the plan late in life, what process stops that from being a quiet rewrite? Third, if a legitimate change is made, how will it be documented so it can't be twisted later? One tactic is to use a living trust instead of a will as the primary estate planning document. A living trust can have a clause that says it is no longer revocable or changeable if the person who made it loses their mental capacity. In other words, it becomes irrevocable if the settlor or trust maker loses capacity. But let's go one step further. Let's say the client who is making the plan is concerned about the possibility of future prospective, that is, presently unknown creditors. Maybe they're worried about getting sued in the future, or maybe having a hospital bill that is greatly in excess of their deductible, or maybe a nursing home expense, and they want Medicaid eligibility. Let's face it, The older we get, statistically, the more likely we'll get dinged with one of these costly events. But even if a client has ample resources to pay for private care, there's one big vulnerability that wasn't on that list. I call it the quiet rewrite. That is the loss caused by having their gift diverted to the wrong person in years to come, because they've succumbed to the frailties I described in the setup to this podcast. So we're protecting against future loss that becomes more probable, that is more likely, the older we get. In this scenario, an irrevocable trust starts to sound like a good tool. But irrevocable trusts limit your right to control the property you put into that trust. But remember, most people who make an irrevocable trust for this purpose do not put all their eggs in that basket. That way, the limits on their ability to use and enjoy trust property don't feel so limiting, because they continue to own other non-trust property. We'll get into some of the different kinds of irrevocable trusts that work well for this scenario in other podcasts. But for now, imagine an irrevocable trust that serves several different but overlapping estate planning goals of the client, or if you're the client. Remember, in this scenario, we want estate inclusion. So to recap, we're making an irrevocable trust. Maybe it's for creditor protection or a hedge against future nursing home costs, but we want an adjusted basis of trust assets upon the death of the trust maker. One of the best ways to ensure a step up in basis is to reserve a testamentary power of appointment in the settlor. What that means in non-lawyer speak is that if you're making this trust, even though technically you give up ownership of the property in the trust, you can still say who gets to own the trust property, but only after you die. To make it clearer, let's imagine you have this beautiful, unique house, and you're getting nervous it might be lost to unforeseen creditors or a nursing home expense, and you just want to make sure it gets to your children after you die. You put it into an irrevocable trust. The trust says something like, when I die, the house is divided between my 3 children. You reserve the right to use the house during your life, but after you're gone, it goes to the kids. Now, because you had no creditor issues or known liability when you made the trust, if one should crop up in the future, it can't touch the house. Also, after 5 years, if you need Medicaid nursing home coverage, the house is protected. It's not an available resource. Now let's layer the tax issue onto that. We need to give you a right over the property sufficient to the IRS so that the IRS continues to consider that house part of your gross taxable estate at death. Why? Because if the kids do sell the house after you die, we don't want them to inherit your low-cost basis. We want the kids to be able to sell the house without being liable to pay capital gains taxes. That's where the limited testamentary power of appointment comes in. You can change who gets the house after death by making a new will. That's why some lawyers jokingly call a power of appointment a power of disappointment, because a beneficiary who thought they were getting the house is cut out or disinherited by the exercise of the power of appointment. Now, let's layer onto that the concern we have in this podcast, the quiet rewrite. The concern that you'll get tricked, bullied, or manipulated into making a new last will before you die. Well, with this plan, we've cut off some of that risk because you don't own your house, and you've limited who you may gift that house to upon your death. In this case, you're only allowed to exercise that limited testamentary power of appointment. In other words, you can only switch the gift between your descendants. But we still don't want you to be tricked into giving the entire house to a descendant who takes advantage of you when you wanted it divided by 3. So how do we fix this problem? Estate planning attorneys use tools. They use the limited testamentary power of appointment, also trust advisor consent structures, and amendment or tax adjustment powers. That's how we're going to preserve the property from the ever more statistically likely sources of loss as you get older. That's how we're going to get the step up in basis at death. Even though the retained power is necessary to keep some flexibility during life and also to get the tax efficiency, there's still a risk. This power of appointment or disappointment creates a vulnerability because it can be exercised late in life, quietly and without oversight. Here's the thing. The capacity to make a will is not all or nothing. There are folks who literally have capacity at certain hours of the day, but not others, or even days of the week. Capacity is not on or off. There's a large gray zone where a person is legally competent, but functionally vulnerable. Clinical literature and everyday experience shows increased susceptibility, increased suggestibility, caregiver idolization, executive function decline, overemphasis on recent interactions, and impaired ability to resist persuasion. Unfortunately, at least for now, the law largely ignores this zone. But good planning should not. So, lawyers out there listening, how do you thread that needle? How do you protect your client's intent, but also not restrict them? Because let's face it, they could be living with this trust for a long time. And things change, and they may legitimately wish to make some adjustments. Maybe it's lifetime gifting that decreases the share of a testamentary beneficiary. The classic, I gave my daughter money for a down payment on her house, and now I have to give her a little less when I die. Or maybe the child who is getting 100% of the estate reneges on their promise to donate a kidney. I don't know. Those are just a couple of examples, but there are many. The solution is not stripping the settlor trust maker of power. It's not to give the beneficiaries the final say. Instead, the goal is to protect the trust maker's original competent intent from being overwritten during vulnerability. Now remember, we're focused on the specific tool, an irrevocable trust drafted to protect a valuable asset. We need to retain a limited testamentary power of appointment. Okay, so here's how we do it. Keep the limited testamentary power of appointment, but treat its exercise as a protected administrative act, not a casual testamentary default. I'm going to repeat that. Elaborate on the event of the exercise of the power of appointment. Give it formality. Remember, if this happens to your client, it's typically going to be with another lawyer, and the client may not give herself away by singing hula-loo. If it happens, it's usually not going to be announced. That means we have to remove the elements of the existing default scheme that would allow the event to be shrouded in mystery, so to speak. Even if the client doesn't want to publicize the disinheritance of a former beneficiary, we still want a record of what happened to confirm that it was legit. What does that look like in drafting? First, we want to shift the default rule. Traditionally, capacity is presumed unless proven otherwise. In the protected structure, the default is no exercise unless capacity is affirmatively shown. Silence or ambiguity defeats the exercise. In plain English, we're not going to assume that a valid will was not the product of overreaching or elder abuse. Next, we want to require contemporaneous proof of capacity. That is, when the client is allegedly changing their mind, we want a snapshot of the capacity at that moment, and it must be documented. What we don't want is retrospective litigation. What we don't want is assumptions. Instead, contemporaneous written confirmation from appropriate medical or neurocognitive professionals addressing not just baseline capacity, but vulnerability to undue influence. And now, for one final assurance, we add an independent gatekeeper. Call that person a trust advisor. I'm going to address a couple of things that come up with the trust advisor role. For one thing, if the trust advisor needs to be independent, can the trust advisor also be a fiduciary to the trust maker? Well, probably not. So why can't we just label the trust advisor a non-fiduciary role in the document? The Uniform Directed Trust Statute. That's why. It's enacted here in Maine, but it's also been enacted in other states. The problem is directed trust statutes change the default rules. In many directed trust states, including Maine and Florida, a trust director or advisor is generally treated as a fiduciary by default. Though the trust instrument can define and limit duties and liability to the extent local law permits. So draft the role deliberately, narrow the scope, clear standard of review, and clean records without creating unintended tax, liability, or Medicaid planning consequences. Lawyers understand that calling someone a fiduciary may cause tax problems, creditor protection problems, or Medicaid availability of assets for the trust maker. What's a trust advisor? Whatever you call it, whether you call it a trust advisor or trust director or trust protector, it's meant to be, in this case, an independent, non-beneficiary, non-fiduciary, to the extent permitted by law, empowered only to say yes or no. In directed trust states, treat this role as a fiduciary by default and draft the limits explicitly, rather than just relying on labeling the role a non-fiduciary. This trust advisor does not decide where assets go, does not balance beneficiary interests, but acts as a checkpoint against exploitation. For the lawyers listening, check your local statute on this and case law. You want to draft the role to comply with the statute, but also you don't want any unwanted side effects. With modern directed trust laws, like, for instance, Maine and Florida, you need to deliberately cabin the fiduciary duties to avoid unwanted tax consequences. Also, we don't want to get into a tangle with DHHS if they're reviewing the trust for Medicaid compliance. Typically, we're concerned with estate inclusion for the adjusted basis, no perception of lifetime control by the settlor, and avoiding the possibility of future lawsuits. This is designed to avoid future lawsuit over whether mom or dad knew what they were doing when they exercised their limited power of appointment or disappointment, as the case may be. By hardwiring this into the trust, we're preventing bad outcomes rather than sowing the seeds of litigation and fighting them later. This will reduce family conflict. This will preserve tax and Medicaid planning. It will create a clear administrative record. It will also honor the settlor's long-term intent. But most importantly, it respects autonomy by protecting it, not by ignoring real-life vulnerability. And that's how we prevent the quiet rewrite. So to recap, how do we avoid a compromised exercise of a limited testamentary power of appointment? We reverse the law's presumption of capacity. We ensure contemporaneous proof of mental capacity, and we have a gatekeeper. Estate planning is not just about documents. It's about how we change in time. A good plan recognizes who the settlor is today, but also anticipates who they may become later. If a plan assumes permanent clarity and independence, it's not only incomplete, but it also doesn't reflect reality. The question most probate courts ask is, was the settlor legally competent on the day they did the signing? The better question is, did the change truly reflect the settlor's independent will, or merely the circumstances of their decline? The protected power of appointment is one way, among others, to answer that question before it turns into a lawsuit, or worse, the wrong person getting the gift. If this was helpful, please like, subscribe, and turn on notifications because we publish new estate planning and elder law episodes designed to help families protect what they've built and to help lawyers design plans that actually hold up over time. If you're a lawyer and you want to study the technical drafting concepts we covered, we're also providing a downloadable clause packet with sample language and structural options related to the protected limited power of appointment, contemporaneous capacity documentation, and gatekeeper consent mechanics. But it's important to remember, these clause packets are for education only. It's not legal advice, and it is not a substitute for independent legal counsel, and it is not intended to be used verbatim in any jurisdiction. Trust and estate drafting is highly state-specific and fact-specific, and you should consult your own statutes, rules of professional responsibility, and tax counsel as appropriate. and your own judgment before using or adapting anything. And if you're a family listening, the key takeaway is simple. A good plan doesn't work on the day it's signed. It doesn't just work on the day it's signed. It's designed to protect intent years later when vulnerability is most likely. I'm Jesse Bifulco, host of Lifecast, the Life Counsel podcast. Thanks for listening, and I'll see you in the next episode.
'Cause I'm hula-loo, I'm a gal that can be true. I do my dancing in the evening breeze, 'neath the trees,